Good evening, viewers. This is attorney Naresh Gehi, and today we're going to have a very important session. But before we get onto today's topic, the most important thing, the biggest headlines for the day are very important. The Trump administration is changing the citizenship exam. This is breaking news for our viewers, and today's topic is going to be about complicated issues in marriage-based immigration cases. Things have changed a lot in the world of marriage-based immigration. So we're going to talk about that. But before that, we are going to educate our viewers about what is going on with the citizenship test. So until now, people had to pass 6 out of 10 questions for the citizenship exam. But from December 1st onwards, from December 1 onwards, people will be tested with 20 questions on the citizenship test, and they will have to pass 12 out of the 20. So to make a long story short, the citizenship exam is becoming difficult. So if you are planning on applying for your citizenship, apply for it as soon as possible. Who are the people who are going to face issues? A lot of people will be facing issues, especially because the officer has the discretion to check whether this particular person understands proper English, whether he can communicate in English properly, whether he can read English properly, whether he can write English properly. So things are getting difficult with reference to the citizenship exam, so apply for it as soon as possible. So according to me, there is a group of people who can have issues with this topic, especially people who are from countries where English is not the first language. For example, if you come from a country wherein they don't teach you English properly and your first language is French, for example, and if you speak basic English, you can have a problem. If Arabic is your first language, and if you had very little education in the English language, you can run into problems. So folks, keep these issues in mind, especially when you are looking at applying for citizenship. So today's topic for the day, very important, complicated issues in marriage-based immigration. So now, what are the issues that we are seeing in marriage-based immigration cases? What I'm seeing is that the trend in granting marriage-based immigration cases is becoming extremely difficult. The immigration officer is asking a lot of questions. And if they suspect that your marriage is not bona fide, then you're looking at trouble. So take an example, you are married, and if there are issues between you and your spouse, the best thing for you to do is to consult any immigration attorney of your choice. Why? Because, God forbid, if you get charged with a marriage fraud on your case, under Section 204C, then it can become an issue. It's very important for us to make sure that you did not enter into the marriage with an intent to circumvent the immigration laws of the United States. Folks, we are getting a question, so let's look at what the question is. So this shows live, so we'll make sure that everything is fine for our viewers. So let me see what is this question from a viewer. Let me see what the question is, a very important question coming here. So folks, the question I just replied to the person is that what happens if you have been charged with a marriage fraud? The problem is that if immigration has charged you with a marriage fraud, your best bet would be to fight that issue out, especially in the same case. Even if you have to go to federal court, it's worth it for you to fight it because it's a very bad blemish on your record. Because once, if you're charged with marriage fraud, and if immigration makes a decision under Section 204C that you failed the citizenship of the adjustment of status interview, and that they don't want to give a green card based upon your marriage because they are suspecting fraud, the problem is that if they say that they have evidence to show that your marriage was fraudulent, then you will not be able to get your green card even if you marry somebody else. You will not be able to qualify for a green card if there is an issue in connection with you getting sponsored by your parents, by your brothers, by your sisters, or whatsoever. So folks, this show is live on Facebook, as you can see. So log on and we'll be happy to take your questions. So it's also a newsfeed. Make sure that you can ask us your questions, and you can also come into a Zoom show and ask us questions. So critically important is that try to make sure that you are fully prepared when you attend your marriage-based immigration interview. Now, what happens in these marriage-based immigration cases? Firstly, I just want my viewers to know that a same-sex marriage is allowed under immigration law. So you can have a member of the same sex marry you. A male can marry a male. A female can marry a female because DOMA, Defense of Marriage Act, has been repealed in the United States. So the good news is that even if you get married to a member of the same sex, the good news is that if you have all the documents and if your intent is to establish a life with your partner, then you should qualify for a green card. Now, let's take some different scenarios where people have problems. Number one, you got married to a member of the same sex or a member of the opposite sex, and your partner, your spouse, is saying that she does not want to come to the interview with you. That's not a good situation for you. That's not a good situation for you because it's up to you to protect your legal rights. There's nothing for you to be scared of. Stand up for your legal rights. You may have rights depending upon the facts and circumstances of your case. So what I would do in this case, the time you realize that your spouse is not ready to cooperate with you in the green card process, immediately hire your own lawyer. Because if there is a lawyer in place, if there is an existing lawyer, he can have a conflict of issue problem in this case. So it would be best for you to change your lawyer or look for another lawyer. Never show up at an interview without your partner, especially when it's an adjustment based upon that application. Because if you go in and if your testimony is incorrect, you may wind up in troubled waters. So please be very careful when you are handling your marriage-based immigration case. So we spoke about the situation wherein you're married to someone and your spouse is refusing to go for the green card interview. You have to protect your rights. Now, what happens if you divorce that spouse? Even if you divorce that spouse, if your second spouse applies for you, so take an example, things didn't work out with the first spouse, you left her, You got married to the second spouse. When you are going to go for the adjustment of status interview with the second spouse, the immigration officer has the right to even ask you about your previous case. Yes, your old case will come up first. Sometimes I get asked this question: how about any other case in which I was denied? A client asked me a question. He said that my labor certification was denied, but now I've gotten married and I'm applying through my spouse. Will that old case come up? The answer is, if an I-140 petition was filed, that case will come up. And still, the officer has the right to ask you questions about that labor certification case also. So your history with immigration is always very important. Now, we spoke about instances wherein your spouse has applied for paperwork and she is refusing to go with you for the interview. Let's take another example here. You are married and you have children from your spouse. You're married, you have children, and your spouse is an American citizen. And he does not want to apply for your green card. But you know he's a citizen. You have a marriage certificate. And he's brutally abusing you. He's mentally torturing you. What can you do? Now, this is a situation wherein you are married to an American citizen. And that US citizen does not want to file your paperwork. Look at this question. He has not filed anything with immigration. You're married to him, you have children, or you may not have children, but you have been with this person for the longest possible time. And if you are a victim of abuse, do you know, even if he has not applied for your paperwork, you may qualify for a green card wherein you can self-sponsor yourself, you can self-sponsor yourself if you have been subjected to extreme cruelty. It can apply to a man or a woman. So let's make life easy. Scenario number one was, you are married and your wife or your husband does not want to go for the interview with you. Scenario number two, you are married, your wife does not want to apply for you at all, or your husband does not want to apply for you at all, and you are stuck in this process. You have legal rights. Scenario number three, you got your 2-year green card. You have your 2-year green card, but now the marriage is not working out. And your US citizen spouse wants a divorce as soon as possible. Don't just give him the divorce. Do not do that mistake. Do not commit that mistake. Maintain a divorce, have a divorce lawyer. Engage the services of a divorce lawyer. My apologies. Engage the services of a divorce lawyer and an immigration lawyer if you are interested in getting a permanent green card. Because if you do not, then immigration reserves the right to deny your permanent green card. Have I seen this happening? Yes, I have seen this happening. So you need to make sure, if you are a conditional green card holder, which means that if you have a 2-year green card, it is critically important for you to make sure, it is critically important for you to make sure that you need to have the divorce, but you need to make sure that you are protected at the same time. If not, your green card may be affected. Now, we spoke about 3 different instances. Number 1 was you are married and your spouse applied for the paperwork here, but now your spouse does not want to go for the interview. And as I said, if that's the situation, retain a lawyer, you may have rights, depending on where your case stands. Second situation, which we spoke about, was very important, was that you are living with your spouse, who's an American citizen, and you've been married to this person for a long time, but this person does not want to apply for your green card. It can also be a green card holder who's doing the same thing to you. So it doesn't matter whether it's a citizen or a green card holder. The third issue is critically important, which I said, is that you have this 2-year green card and now your spouse is not cooperating. Be very careful. Make sure that you have a very good divorce lawyer and an immigration lawyer, especially because if your paperwork is in the pipeline, your case may be affected. Now, the fourth situation, which I've seen, is very important. You went for the marriage-based interview with your spouse, and unfortunately, the immigration officer was not very happy with the interview. What do? We have an issue here. He can call you for a Stokes interview. What is a Stokes interview? A Stokes interview is an interview wherein they can separate you from your spouse. And if you get separated from your spouse, and if your questions do not match properly, that can become a problem. Your case can be denied, but if all your questions don't match, then the immigration officer can suspect the case to a case of marriage fraud. So this is the fourth situation wherein you went with your spouse and you are called at the second interview. Make sure that you protect your legal rights. Go with any experienced lawyer. Go with any experienced lawyer of your choice. Protect your case. The problem is that if the case gets damaged, you can be in troubled waters for no apparent reason. You can be in troubled waters for no apparent reason. And I've also seen cases wherein ICE has put people in deportation proceedings, commonly referred to as removal proceedings. So the fourth situation, I said, is that you went with your spouse to the interview and your interview did not go well. What do? Come prepared next time. Fire with all your guns. That is going to be very important for you folks. And if you fire with all your guns at the Stokes interview, if you pass it, fantastic. We've had cases wherein people were called for a Stokes interview. We went for the Stokes interview and our clients have passed. Prior results do not guarantee future outcome, but fight for your legal rights. Don't give up. Fight. When the great get going, the going gets great. Another example I've seen is that you have sponsored your spouse in a foreign country. You have sponsored your spouse in a foreign country. And your spouse went for the interview. You have a happy and a wonderful marriage, but unfortunately, the consulate officer, the consulate officer said that I cannot give you the green card. You have to wait because your case is in administrative processing under Section 221G of the Immigration and Nationality Act. And you're sick and tired of the wait. The case may take some time. People tell me they've gone to Congress people and nothing much has happened. But when the time is right, you still have legal rights. But there's a time and place wherein you can take these cases to federal court. If your case is pending for a long time, and if there is no blemish, which means if your marriage is bona fide and you're in that situation wherein you love that person very much, and your case is stuck up in immigration for the longest possible time, you can take it to federal court and you may be getting a decision within 6 to 8 months. Yes, folks, we've taken these cases to federal court and we were able to get a decision. The decision may be in your favor. If it's a great marriage, everything well and good, your spouse will be here. So don't wait in the game. Another issue which I've seen in marriage-based immigration cases is that you have applied for your citizenship based upon your marriage to an American citizen. You're living with your spouse. You applied for your citizenship. You paid the immigration fees. You were fingerprinted by immigration. And after that, you went for your interview. And your wife is also worried, or your husband is also worried, why is this citizenship taking so long? What are your rights? You can take it to federal court. If your case is pending, and if immigration has not given you a decision, then you should consider taking those cases to federal court. Those are your legal rights, folks. And if I were you, if you are in that situation wherein you need your citizenship right away, consider federal court. That is very important for you folks. And you'll get a decision. And I've seen cases which were stuck up in the pipeline for more than 3 years, 4 years, 5 years. Federal court is a good option. And I know that there are not many federal lawyers. That's because federal law is very difficult and a lot of lawyers don't like to do federal work. So based on my experience, when we do federal work, we look at the case, we want to make sure that everything is properly taken care of, and then only you should file your cases in federal court. But never go to federal court when you have a weak case. It's not good for you folks. Because the job of the federal court is to direct immigration to make a decision on your case. And if everything is well and dandy, the good news is that you will get the desired result. I mean, I've seen cases wherein people have been stuck up in foreign countries for no apparent reason. We took it to federal court. So we had the assistant US attorney speak to us, on behalf of the government. We explained the case, straightforward case, the family was here. So you should not wait forever, especially when you have exhausted everything. The most common answer which I get is that, Mr. Gehi, I went to this congressman's office. I went to the senator's office. I went to the senator's office and they wrote a letter. But the reply from immigration was that your case is pending for administrative proceeding. So you don't have to wait for that. Take it to federal court. That's the only time you'll get a proper answer from immigration sometimes. So this is meant for people who have any complicated issues in marriage-based immigration cases. I heard of a story recently wherein this particular woman came to the United States on a green card, and she was living with her husband, and suddenly the in-laws decided to put her on the plane and tell her to go back to the home country. Don't do that, folks. If you have your green card, you have rights in this country. No one can force you to leave the country. Nobody can. You have legal rights in this country. And one other thing which I've noticed is that when you're married, when the marriage breaks off, the US citizen spouse sometimes threatens you by saying, I'm going to get you deported. Speak to an immigration lawyer. Nothing for you to worry about, especially when you entered the marriage in good faith. You have legal rights. Stand up for your rights. Let him not blackmail you. And there's nothing to be scared. And if you are a victim of abuse, call the police. Create a record. Fortune favors the brave. A stitch in time saves 9. So make sure that you create a record. Those issues are very, very important. So I have 1 or 2 questions here, but if you have any questions, feel free to ask us. There's a question from Bobby Woodward from Facebook. Where are the main consulates for Bangladesh? The main consulate for Bangladesh is in Dhaka. DACCA, Dhaka has the main consulate in Bangladesh. If you're in India, it's Mumbai, but if in Bangladesh, it is Dhaka. So folks, I think we've had a very good session. And in every marriage-based immigration case, we discussed 4 categories today, 4 or 5. Number 1 was that if you are married to a citizen and you're living here, and if your spouse is refusing to go for the green card interview, you may have legal rights. So don't be scared of your US citizen spouse. Stand up for your rights. Second is you are married to an American citizen or a green card holder, and you've lived with this person forever. This person does not want to sponsor you, and this person is seriously abusing you. You may be able to self-sponsor yourself depending upon the facts and circumstances of your case. Number 2. Number 3 is you went for the interview with your spouse and your interview did not go well. And immigration is asking you to come in for a second interview. Please make sure that you take a lawyer with you. It's very important for you to protect your case. Number 4 was you have a temporary green card and now your spouse wants to divorce you, especially when you have a 2-year green card. Be very careful. Doesn't matter in which state you live in. There can be an impact on your permanent green card. There can, yes, there will be an impact. There may be an impact on your permanent green card. That is critically important. And the 5th situation was that you have sponsored your spouse and your spouse is stuck in that foreign country forever. Consider taking those cases to federal court. So folks, this is Attorney Naresh Gehi. We had a very interesting and a fantastic session. And before I leave, the citizenship test is changing from December 2020. Apply for a citizenship as soon as possible. So if you have any other questions, you may reach us at 718-263-5999. And we handle immigration cases from all over the United States and the world. Doesn't matter in which state you live. And the easy way to reach me directly is info@gehilaw.com. Let me move a bit, info@gehilaw.com. And if you want to email us, info@gehilaw.com, reach us and we'll be happy to assist you with your immigration matters. The instant program constitutes an attorney advertisement under the laws of the state of New York. We'll be back again with our viewers next week at 6:30 p.m. Eastern Standard Time. Keep watching this program, Green Card with Gehi, brought to you by Naresham Gehi. And don't forget, share the show with people who have immigration issues. Thank you all.